Welcome to the 78th, correct, annual Honorable James R. Browning Distinguished Lecture in Law. My name is Hillary Wandler, and I was privileged to clerk for Judge Browning after I graduated from law school. Judge Browning had a long and distinguished legal career that started in Montana. He grew up in Belt, Montana, a place about which he said he could not imagine a better place to grow up, which is really fun to hear. He earned his law degree with honors from what was then known as Montana State University, but is now the University of Montana. He graduated at the top of his law school class with a perfect academic record. Something to live up to. He then worked in the DOJ's antitrust division and worked his way into several important positions in the federal government, including the executive assistant to the Attorney General of the United States, and later the clerk of the United States Supreme Court. After law school, he also served in the military and earned a Bronze Star for his military service in World War II. While Judge Browning was clerk of the United States Supreme Court, he famously, at least to us, held the Bible for John F. Kennedy as he was sworn in as President of the United States. And then 7 short months later, President Kennedy appointed Judge Browning to the federal bench on the Ninth Circuit Court of Appeals. Judge Browning took the helm of the Ninth Circuit as Chief Judge in 1976, a position he held for 12 years. Through technological advances, he addressed inefficiencies that to that point had felt intractable because of the circuit's large size. In doing so, he protected the circuit from division, and he improved its productivity and effectiveness. He was known for his ability to build consensus and his preference for unanimous decisions. I could tell you many stories about Judge Browning, both from my time working for him, but also just the history about him is absolutely incredible. But today I wanted to share a couple of comments from fellow judges. They described Judge Browning's work as Chief Judge as transformative. Justice Kennedy described his work this way: Jim Browning built upon and strengthened the Ninth Circuit tradition of judicial independence, and did so during a time when the dramatic expansion of the caseload might well have led a less imaginative and committed man to go in the opposite direction. With his warmth, good sense, and devotion to the law, Jim Browning was the right person in the right place at the right time. I think that pretty much sums up his entire career, actually. Ninth Circuit Judge Goodwin noted that shortly after Judge Browning took the helm, the court actually doubled in size, and just 5 years after that brought on several more active judges. So it was just growing when he took the Chief Judge position. He also believed Judge Browning was the best person for the job. He said, Jim Browning meets every problem with a smile. He combines optimism with the ability to cause persons of widely different views to work together to solve problems. His ability to develop harmony within an institution of strong-minded, independent men and women has provided a remarkably smooth operation while preserving the independence and individual expression in the important work of deciding cases. That sounds like someone we need today, don't you think? Those of us who worked for and with Judge Browning can only hope. Some of his character and positivity and creativity and warmth rubbed off on us. He was special. So I wish you could have known him. I'll sit down now.
What a great colleague, and he would have been so proud. He was so proud of Hillary. I actually had the chance to visit Hillary in San Francisco when she was clerking for the judge. I'm going to introduce Judge Tallman in a second. I do have a little story about Judge Browning. And that is, I was having lunch with him one day in San Francisco, and I said, I just have a couple questions about how you got to be where you are. And he said, sure, ask. We were walking through the Tenderloin to his favorite lunch counter. He did not eat in fancy places. And some bum, homeless guy, came up and slapped him on the back and said, how you doing, you old guy? Judge Browning. But right after that, I said, he said, ask me your question. And I said, so I don't understand how you got to be the clerk of the Supreme Court. And he said, oh, that was easy. Bobby Kennedy just called up and asked me. I was like, yeah, that's the part I don't get. So now to introduce Judge Tallman, even if it's a little bit of a joke, tall man, short woman. And then all the allusions to short and little all apply to Judge Browning and myself, not to Judge Tallman. So I am honored to be here for this lecture in this series, and there are increasingly fewer of us in this room who knew Judge Browning. But that is why it is such an honor to have a successor, Judge Tallman, here for you all to hear, to learn from, and to meet. I know Judge Browning would be delighted because this lecture combines the things he loved the best, this law school and the Ninth Circuit. Judge Browning took senior status in 2000, the same year that Judge Tallman got appointed to and started his service on the Ninth Circuit. As you know, he served there for 18 years, taking senior status in 2018. Judge Tallman has been a great friend to this law school over the many years now. He's been here many times. He's been a commencement speaker. He served, I think you were here for at least one panel where the court had hearings here. He's been a CLE speaker, and he's been a great mentor to Montana law students, one in particular whom he hired as his clerk, Jessie Moats. A young woman from Great Falls, terrific student, but really hadn't had a life opportunity to get outside Montana. I don't think she had not been out of the state of Montana until she went to work in Seattle for Judge Tallman. And her life experience there changed her life, not just because of the geographic location, but largely because of the mentorship of Judge Tallman in the big city of Seattle. He took her to a lot of other big cities on panels across the Ninth Circuit. He encouraged her to stay an extra year. Isn't that right?
Yeah.
Yep.
Actually, she spent 3 years.
3 years clerking for the judge. And then with his guidance, she went to work for the DOJ in Washington, D.C. And now she's an assistant Attorney General for the state of Alaska in Anchorage, doing amazing work on behalf of the state. And she owes all of that to her mentor when she got out of law school, Judge Tallman. So 40 years ago, we were just talking about this. We graduated from law school in the same year. 40 years ago, Judge Tallman was a 3L, just like many of you here. And as many of you hope to do, he got to start his law career by serving as a law clerk at the trial level, which gave him some extra ammunition to go on to a great career as a trial lawyer. And you know from the biography printed on the program that he served 4 years as a criminal prosecutor, first again with the DOJ in D.C., and then as an assistant U.S. attorney in Seattle. And then he went into private practice in Seattle on both sides. Well, not on both sides. You weren't prosecuting in private practice. That's not possible. But doing criminal defense work and civil work. And it just isn't true that lawyers don't try cases anymore. Judge Tallman is a great example of that. He tried more than 36 cases, it says. How many is that? 36. That is a lot of cases. And argued 15 cases on appeal. So you're not confined either to just the trial or just the appellate practice. And it was those 21 years in active litigation practice that made him so especially suited for the Ninth Circuit. And you know, if you were at the lunchtime talk, that his appointment as a Republican by a Democratic president, Bill Clinton, as a result of a combined effort of, it was a Republican and it's Slade Gorton, who was at Davis, right when I was? Slade Gorton and his fellow senator across the aisle came together, and the president nominated and was confirmed. So a bipartisan appointment to the Ninth Circuit based on what? Qualifications. Isn't that the perfect way to do that? And so the question is, okay, what happens when you get on the Ninth Circuit? It is a crazy hard job, time-consuming, thousands of briefs to read, digest, thousands of opinions to write, and Judge Tallman did all of that work well, efficiently, but he went beyond that and has always done more. Probably nearest to my heart, if you've been in my classes, he was the chair of the advisory committee. We talk about advisory committee notes daily, isn't that right? Yeah, daily. So he was the chair of the advisory committee, not in my line of work, but on the criminal rules for the Judicial Conference. And he served by designation as a trial judge in districts all through the Ninth. He was at one point the only federal judge in the courthouse in Billings, the U.S. courthouse in Billings. Everybody else was out sick. Called away to a conference, he was the only one. So he was adept at both the trial level and at the appellate level of judging, all because of his great litigation background and intelligence and hard work. And then, the subject of tonight's talk, in 2014, Chief Justice John Roberts appointed Judge Tallman to a 7-year term on the, I have to look this up, I always forget, Foreign Intelligence Surveillance Court of Review. Only 3 judges in the whole United States are on that court. Each has a 7-year term. Judge Tallman is the middle judge right now, as I saw. And that is the subject of his lecture tonight. It's also a subject on which I know nothing, so I'm going no further than that. But I'm going to sit down and learn, and I think you'll all join me in thanking you, Judge Tallman, for coming here and for your work with our law school.
Thank you both for that very kind introduction. Hillary, I have to tell you one Judge Browning story. I don't think I'd been on the court more than about 6 months, and they assigned me to a panel with Judge Reinhardt and Judge Browning. It was an environmental case involving a challenge and a timber sale that was grizzly bear habitat, and the logging contractor needed an easement from the Forest Service to reopen a third of a mile of logging road to get to the timber, the stand of timber. And as you can imagine, there was quite a protracted fight with the environmentalists over whether or not this road should be reopened. And so it was a very impassioned argument to the panel. And when we got into the conference room, Judge Reinhardt, who was presiding, turned to Judge Browning and said, well, Judge Browning, how do you think this case should be decided? What's your vote? And with a twinkle in his eye, he looked at both of us and he said, I vote for the Bears. And then you reminded me of another story about Jessie that I'll tell. I think our first sitting when she came to work for me was in San Francisco. And as Professor Ford said, she had never been outside the state of Montana until she came to interview for the job with me. So the other 3 clerks asked if they could go early down to San Francisco on Friday afternoon so that they could show Jessie around the city. And I got down on Sunday night and asked, Jessie, how was the tour around the city this weekend? And to my horror, I was told by Jessie that it was the weekend of the Gay Pride Parade, and they had taken Jessie to the Castro district. And I said, so Jessie, what did you think of the parade? And she said, well, I saw some things that I couldn't tell my grandmother in Great Falls. And in Montana, we wear jeans under our chaps. Well, good evening. I am really honored to be asked to deliver this lecture named in honor of a great Montanan and my beloved colleague for several years before his passing. Jim Browning remains a legend on our court, and this lecture series is a fitting tribute to a brilliant jurist and to a genuinely caring human being, and we all miss Judge Browning. Then Chief Judge Bruce Selya from the First Circuit, while serving on the Foreign Intelligence Surveillance Court of Review, which we call the FISCR, F-I-S-C-R, in 2008 articulated the mission statement of the judiciary when reviewing the domestic surveillance powers exercised by the United States in furtherance of national security. He wrote, "Our government is tasked with protecting an interest of utmost significance to the nation, the safety and security of its people. But the Constitution is the cornerstone of our freedoms, and government cannot unilaterally sacrifice constitutional rights on the altar of national security. Thus, in carrying out its national security mission, the government must simultaneously fulfill its constitutional responsibility to provide reasonable protections for the privacy of United States persons. The judiciary's duty is to hold that delicate balance steady and true." Tonight, I will explain what led to the passage of the Foreign Intelligence Surveillance Act and its creation of the two FISA courts, and describe the grand bargain that was struck between our three branches of government when creating FISA's judicial review procedures over domestic espionage and counterterrorism investigations. My hope is to leave you with a keener understanding of how we have arrived at where we are today and how the judiciary understands its oversight role within FISA's statutory framework under the Constitution. One word of caution. As a currently serving judge on the Fisker charged with reviewing sensitive classified matters, I will not be discussing with you today any of the cases underlying the more sensational news items concerning the work of the FISA courts that you may have heard or read about over the past few years, and in particular, very recently. My talk will deal more with history than with current events. I begin with a brief overview of the current structure of the United States intelligence community in order to provide you with a sense of its scope, and then I will turn to the history and case law that led to FISA's passage and subsequent evolution. I will close by reiterating the key concepts I hope you take away from my lecture to aid you in understanding what the FISA framework requires all of us to weigh in considering the substantial questions of constitutional law impacting the privacy versus security debate, which continues to this day. As judges, we do this work in order to ensure that we all remain safe and secure while holding steadfast our fealty to the cornerstone of our freedoms. When you think of the intelligence agencies, you probably think of the Central Intelligence Agency, the FBI, and the National Security Agency. And in fact, prior to 2004, the United States intelligence community was supervised by the Director of Central Intelligence, who also ran the CIA. But in 2004, as part of its response to the terrorist attacks of September 11, 2001, Congress passed the Intelligence Reform and Terrorism Prevention Act, which, among other things, established the Office of the Director of National Intelligence, we call him the ODNI, to better unify and manage the efforts of the intelligence community. And in the words of the ODMI, the U.S. intelligence community is a federation of executive branch agencies and organizations that work separately and together to conduct intelligence activities necessary for the conduct of foreign relations and the protection of the national security of the United States. The ODNI supervises the gathering and the analysis of intelligence for the President, the National Security Council, the heads of departments and agencies of the executive branch, the chairman of the Joint Chiefs of Staff and senior military commanders, and Congress. In addition to the ODNI, the U.S. intelligence community members include the CIA, an independent agency, and various agencies and military branches within the Department of Defense, including the National Security Agency, the Departments of Energy, Homeland Security, Justice, including the FBI and the DEA, State, and Treasury. These members, to varying degrees, oversee or employ 6 basic intelligence collection disciplines. First, signals intelligence. Think what the NSA does. Second, human intelligence. Think not just espionage involving spies and counter spies and double agents, but also overt collection by, for example, debriefers and military attachés. Third, imagery intelligence. Think photography, film, and radar, among others. Fourth, geospatial intelligence. Think satellites. Fifth, open source intelligence. Think the news media and all the other places that you get information from. And sixth, likely of least familiarity to you, measurement and signature intelligence, which is, stay with me here, technically derived intelligence data other than imagery or signals intelligence that draws from various disciplines. As an example, optical, acoustic, for example, the acoustic signature of a ballistic missile submarine as it plies the waters, seismic, and materials science. As you can see, the distinct members of the intelligence community make up a complex and highly technical network, which is important to bear in mind as we look at the evolution of the legal framework we use to govern sophisticated intelligence gathering in the modern era, including the ways in which technological developments drive that evolution. We began our discussion of the history of electronic surveillance law with the Supreme Court's 1928 decision in Olmstead versus the United States, which examined the question whether the use of private telephone conversations between the defendants and others, intercepted by means of wiretapping, amounted to a violation of the Fourth and Fifth Amendments. The case actually arose in my former duty station of Seattle, Washington, where petitioners, plus some 72 others, were indicted for violations of the National Prohibition Act. In other words, bootlegging whiskey on a grand scale, a scale so grand that it included numerous cargo vessels, underground storage caches, a central office manned with operators, and the employment of executives, salesmen, deliverymen, dispatchers, scouts, bookkeepers, collectors, and an attorney. The information which led to the discovery of this liquor conspiracy was largely obtained from wiretaps clipped to the ordinary telephone wires leading from the residence of the petitioners and from the basement of the central office building. Importantly, the taps were installed without trespass upon any property of the defendants. One of the questions before the Supreme Court then was whether a wiretap was the kind of qualifying search protected by the Fourth Amendment, which I know you can all recite from heart. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So here's what the court decided. It wrote, "The amendment does not forbid what was done here. There was no searching, there was no seizure. The evidence was secured by the use of hearing, and that only. There was no entry of the houses or offices of the defendants." Although this sounds surprising to us now in light of subsequent case law, The Supreme Court in 1928 held that wiretapping simply was not the kind of search against which the Fourth Amendment protects. But the court also issued an explicit invitation to Congress to legislate in this arena, writing, "Congress may, of course, protect the secrecy of telephone messages by making them, when intercepted, inadmissible in evidence of federal criminal trials by direct legislation." And that is what Congress did in the Communications Act of 1934. So here I submit to you is an example of a technological development, the widespread use of Alexander Graham Bell's new telephone, causing the judicial branch to answer a novel legal question about the investigatory powers of the federal government, and particularly the executive branch. But when the legislative branch did not like the answer given by the judiciary, it stepped in to adjust the balance by statute. The Communications Act of 1934 combined and organized federal regulation of telephone, telegraph, and radio communications and created a new agency, the Federal Communications Commission, to oversee and regulate these industries. And as written in 1934, it provided, among other things, quote, that no person not authorized by the sender shall intercept any communication and divulge or publish the existence, contents, substance, purport, effect, or meaning of such intercepted communication by any person, end quote, on threat of fines and imprisonment for willful and knowing violations. Now, in 1937, in Nardone versus the United States, the Supreme Court had to decide whether, in view of these statutory provisions, evidence procured by a federal officer's tapping telephone wires and intercepting messages was admissible in a federal criminal trial. It concluded that, taken at face value, the phrase "no person" comprehends federal agents, and the ban on communication to any person bars testimony to the content of an intercepted message. In response to the government's argument that surely Congress had not intended to hamper and impede the activities of the government in the detection and punishment of crime, the court responded that it would not address this policy question, and that Congress may have thought it less important that some offenders should go unwhipped of justice, and I've got to use that in an opinion sometime, then the officers should resort to methods deemed inconsistent with ethical standards and destructive of personal liberty. Again, we see the judiciary here acknowledging that it is the responsibility of the legislative branch to adjust the balance when it comes to privacy issues. But the judiciary has a role in protecting privacy too. In the case of Katz versus the United States in 1967, the Supreme Court once again examined the question whether the Fourth Amendment protects against electronic surveillance. And this time it reached a somewhat different conclusion than it had reached in Olmstead. In Katz, the petitioner was charged with transmitting illegal bets from Los Angeles to Miami and Boston using a public payphone in an enclosed booth. Federal agents had placed a listening device on the outside of the phone booth without obtaining a warrant. And Mr. Katz asked the Supreme Court to decide whether a public telephone booth is a constitutionally protected area so that evidence obtained by attaching an electronic listening recording device to the top of such a booth is obtained in violation of the right to privacy of the user of the booth. Rather than answering that question directly, the Supreme Court came up with a different formulation. It wrote, "This effort to decide whether or not a given area viewed in the abstract is constitutionally protected deflects attention from the problem presented by this case." The court continued, "For the Fourth Amendment protects people, not places. What a person knowingly exposes to the public even in his own home or office, is not a subject of Fourth Amendment protection. But what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Accordingly, the court held the government's activities in electronically listening to and recording the petitioner's words violated the privacy upon which he justifiably relied while using the telephone booth, and thus constituted a search and seizure within the meaning of the Fourth Amendment. Or, in the words of Justice Harlan's concurrence, the language with which you all are likely familiar, the unauthorized listening device violated Katz's constitutionally protected reasonable expectation of privacy. In the wake of the Katz case, and in response to congressional investigations showing the widespread continued use of wiretaps without legal authority, Congress enacted the Omnibus Crime Control and Safe Streets Act of 1968, which included what we refer to affectionately as Title III. Title III is also called the Wiretap Act, which established stringent warrant procedures for monitoring and recording telephone calls that prosecutors must follow to be consistent with the Fourth Amendment for use in criminal investigation. I'll talk about those judicially supervised procedures more in a moment, but here again, you see Congress acting in response to actions by the executive branch and decisions by the judicial branch in order to strike a better balance between privacy rights and the needs of law enforcement. But what about cases involving not just ordinary crimes, but national security concerns? The Supreme Court deliberately refused to reach that question in Katz, dropping a footnote that reads, whether safeguards other than prior authorization by a magistrate would satisfy the Fourth Amendment in a situation involving the national security is a question not presented in this case. The court did not consider and did not decide whether there could be a national security exception to the Fourth Amendment's warrant requirement. And Title III, as originally drafted, included a proviso that nothing herein shall limit the constitutional power of the President to take such measures as he deems necessary to protect the nation against actual or potential attack or other hostile acts of a foreign power, to obtain foreign intelligence information deemed essential to the security of the United States, or to protect national security information against foreign intelligence activities. Indeed, national security surveillance, simply authorized by the President, was then ongoing and largely not subject to judicial review of any kind. For example, in May 1940, President Franklin D. Roosevelt authorized Attorney General Robert H. Jackson, who later became Justice Jackson on the Supreme Court and was the lead prosecutor at the Nuremberg trials. The President authorized the Attorney General to use wiretapping in matters involving the defense of the nation, and electronic surveillance was used in domestic security cases at least since 1946. I have in my office a copy of the one-paragraph justification signed by FBI Director J. Edgar Hoover during the administration of President John F. Kennedy, and the signed authorization by Attorney General Robert Kennedy permitting the tapping of the telephone of the Reverend Dr. Martin Luther King, dated October 10, 1963. Most famously, these practices intensified under President Richard Nixon, who blurred the line between foreign and domestic security purposes and used wiretapping as a tool to identify political enemies both abroad and at home. As you may know, these abuses were eventually uncovered and aggressively investigated by the Church and Pike committees in Congress. But the judiciary was also examining some of these issues as illustrated by the Keith case decided by the Supreme Court in 1972. The Keith case arose from a criminal proceeding in the Eastern District of Michigan in which the United States charged 3 defendants with conspiracy to destroy government property. One of these defendants, Larry Plamondon, an anti-Vietnam War activist, was charged with the dynamite bombing of a CIA office in Ann Arbor, Michigan. During pretrial proceedings, it was revealed that the Attorney General had approved warrantless wiretaps to gather intelligence information deemed necessary to protect the nation from attempts of domestic organizations to attack and subvert the existing structure of the government. The government argued that this was a reasonable exercise of the President's constitutional power to protect the national security, and therefore no warrant was required. The court was faced in Keith with deciding this time in a case that conceitedly did not involve any foreign power or foreign intelligence, whether there is a national security exception to the Fourth Amendment warrant requirement. Once again, the Supreme Court managed to dodge the question, this time distinguishing between foreign intelligence and domestic intelligence. The court refused to say how it would rule if the case had involved foreign threats, stating simply, this case involves only the domestic aspects of national security. We have not addressed and expressed no opinion as to the issues which may be involved with respect to activities of foreign powers or their agents. The court also acknowledged the difference between attempts to gather evidence for specific criminal prosecutions, which the government argued it was not initially engaged in here, and surveillances directed primarily to the collecting and maintaining of intelligence with respect to subversive forces, that is, ongoing intelligence gathering as authorized by the Attorney General in that case. But as to the latter, the court concluded that it would not make the requested departure from Fourth Amendment standards because these circumstances did not justify complete exemption of domestic security surveillance from prior judicial scrutiny. It held that the government was required to follow an appropriate warrant procedure in the Keith case. Interestingly, however, the court signaled it was open to employing different but perhaps less stringent warrant procedures in the domestic intelligence context than in the realm of criminal investigations governed by Title III applications. The court said, given the potential distinctions between Title III criminal surveillance and those involving domestic security, Congress may wish to consider protective standards for the latter, which differ from those already prescribed for specified crimes in Title III. Different standards may be compatible with the Fourth Amendment if they are reasonable, both in relation to the legitimate need of government for intelligence information and the protected rights of our citizens. For the warrant application may vary according to the governmental interest to be enforced and the nature of citizen rights deserving protection. If Congress had responded to this invitation from the Supreme Court, perhaps we would now have a DISA, that is, a Domestic Intelligence Surveillance Act, in addition to FISA. As it happened, however, given the wide range of intelligence abuses by federal agencies during administrations of both political parties identified in the Church Committee report, there was no appetite in Congress to carve out a separate procedure for domestic surveillance intelligence. Rather, distinguishing only between foreign intelligence surveillance and domestic criminal prosecutions, Congress focused its energies on developing FISA, to which I will now turn. Congress passed the Foreign Intelligence Surveillance Act in 1978. It is codified at Title 50 of the United States Code, beginning with Section 1801 and so on. As originally enacted, FISA was designed to provide a process for intelligence agencies to seek a warrant for surveillance inside the United States of activities orchestrated here or from abroad, but with relation to carrying out in the U.S. by foreign powers and their agents. After I review for you what FISA, as originally conceived, authorizes, I will describe what each branch of government gave and what each branch got out of this grand bargain. At the most basic level, FISA gave a role to each of the three branches of government in regulating foreign intelligence surveillance, which, as is hopefully apparent from the historical background I have just reviewed, was not always the case. FISA, simply put, authorizes the federal government to engage in four types of investigative activity in connection with certain national security investigations: electronic surveillance, physical searches, the use of pen registers and trap and trace devices, and compelling the production of tangible things. All of this activity must be directed at a foreign power or agent of a foreign power. And for purposes of conducting counterterrorism investigations, seeking to prevent another 9/11 from happening, terrorists are treated under the statute like agents of foreign powers, even if they owe allegiance to an international terrorist group like ISIS, which is treated akin to a non-nation state. As with applications for Title III warrants in the federal criminal context, FISA requires an affidavit of probable cause, although the probable cause showing is distinct from that required under Title III. Instead of showing, as Title III requires, that there is probable cause to believe that an individual is committing, has committed, or is about to commit a particular enumerated offense, a FISA affidavit must establish probable cause to believe four things: that the target of the surveillance is a foreign power or agent of a foreign power, which, as I mentioned, can include agents of foreign political organizations and groups engaged in international terrorism, as well as agents of foreign nations. Two, that each of the facilities or places at which the electronic surveillance is directed is being used or is about to be used by a foreign power or agent of a foreign power. Third, that a significant purpose of the surveillance is to obtain foreign intelligence information. And four, that appropriate minimization procedures are in place. Also distinct from the Title III warrant sought by street-level case agents, FISA applications must be approved at the highest levels of government, personally by the Attorney General or the Deputy Attorney General, and they must be certified by the President's National Security Advisor or an equally senior designee, often the Director or Deputy Director of the FBI, the CIA, or the NSA. FISA also established the Foreign Intelligence Surveillance Court, which we refer to as the FISC, to review FISA applications and issue orders, and its Court of Review to hear government appeals from denials of applications or challenges by third parties ordered to produce information. The Chief Justice of the United States designates federal district court judges to serve as judges on the FISC. Currently, there are 11 such judges who serve staggered 7-year terms. The judges designated must represent at least 7 of the judicial circuits, and 3 of the judges must live within 20 miles of the District of Columbia. The Chief Justice also appoints 3 federal circuit court judges to the Foreign Intelligence Surveillance Court of Review, or the FISCR. And I was appointed, as Professor Ford mentioned, in 2014, and my term will end in 2021. Appeals from the FISCR may be taken to the Supreme Court, but to date the Supreme Court has not yet taken a case from any of our decisions. So what does the FISA application process look like? Applications are generally presented to the duty judge by Justice Department attorneys from the Office of Intelligence within the National Security Division, and on behalf of the agency with primary investigative or intelligence gathering authority over a particular matter. Those attorneys first file a proposed application for an order, which is reviewed by legal advisors, sort of staff attorneys, I guess we would call them in the Ninth Circuit, of the FISC. The legal advisors oftentimes begin discussions with the government attorneys regarding the sufficiency of the probable cause showing and the scope of the requested order. The FISC judge on duty to handle the application will also consult with his or her legal advisors, and the FISC judge can approve or deny the application or request additional modifications. About 20 to 25% of the time, the FISC judge requires more information or better articulation of probable cause. In the Director of the Administrative Office of the U.S. Courts' most recent report to Congress, the FISC disclosed, and this was classified when I came on the court in 2014, but it has now been declassified by Congress in the executive branch. The FISC disclosed that it had received 1,614 FISA applications in 2017. After consideration by the court, 1,147 were granted, 391 orders were modified, 50 orders were denied in part, and 26 applications were denied in full. The 11 FISC judges examine the applications brought before them with a discerning eye, and they do not issue these orders lightly. In no way is this court a rubber stamp for whatever the government wants to do. Now, with this process in mind, and compared to how foreign intelligence surveillance was conducted in the past, I think it is fair to say that each of the three branches of government compromised in order to reach FISA's delicate balance. First, the executive branch. It gave up the potentially unilateral authority to conduct foreign intelligence surveillance without any oversight, left open by the Supreme Court's decision in the Keith case, and agreed that foreign intelligence surveillance conducted inside the United States is to be governed by the statute. In return, the executive gained legitimacy because its practices and procedures are endorsed by the legislature and authorized by the judiciary, and the executive can rest assured that evidence obtained after properly following FISA's procedures can be used in court should a prosecution ensue. Next, the legislature. It gained the ability to oversee through regular reporting by the intelligence community and to regulate through oversight the exercise of executive power that heretofore it had not touched. In this regard, it is worth remembering that Congress still does not regulate foreign intelligence surveillance conducted completely outside the United States. That work is mostly governed by a presidential executive order, 12333, which was issued by President Ronald Reagan in 1981 under the president's constitutional authority over foreign relations and as commander-in-chief. Congress also gained oversight power through its intelligence committees, including the House Permanent Select Committee on Intelligence, the Senate Select Committee on Intelligence, both established shortly before FISA was passed, and the judiciary committees of both chambers. Understandably, however, congressional oversight of foreign intelligence surveillance mostly happens behind closed doors, which is a departure from Congress's usual practice of conducting all proceedings in public. And the reason for so much secrecy in this arena, as I'm sure you can appreciate, is to prevent the disclosure of the methods and means by which intelligence agencies gather specific information and to protect ongoing investigations. And the best example I can give of that is that in the 10-year hunt to track down Osama bin Laden after 9/11 when he learned of our capabilities in monitoring cell phone communications that his underlings were using. He immediately ordered all of his people to stop using their cell phones, and they went to human couriers. If any of you have seen the movie Zero Dark 30, which I think it was Jessica Chastain, I think, was the actress who did such a phenomenal job portraying the CIA intelligence analyst who literally devoted 10 years of her life to tracking down Osama bin Laden, and ultimately resulted in the president ordering SEAL Team 6 to go to Abbottabad, Pakistan, and to take out Osama bin Laden. That's the best example I can give you. That movie portrays how difficult it was to conduct on-the-ground surveillance of human couriers that ultimately they were able to follow and track to the compound in Abbottabad, in Pakistan, where Osama bin Laden was hiding out. And to get back to my prepared remarks, finally, the judiciary, it gained oversight over an individualized warrant procedure for the kind of national security surveillance that might impact U.S. citizens it had previously steered clear of reviewing. Rather than simply deferring to the President's Article 2 responsibility to protect the security of the nation, the judiciary, at least as to foreign intelligence surveillance conducted within the United States, now had a clearly articulated role to play. But this role raises some interesting questions. For example, does an application to conduct surveillance under FISA satisfy Article 3's case or controversy requirement? Now, those of you who take federal jurisdiction will know what I'm talking about. If you don't take the class, it's really a good one to take if you want to clerk for a federal judge. Unlike with Title III warrant procedures, where it's understood that obtaining a warrant is very likely ancillary to a subsequent criminal prosecution and adversary proceedings to later challenge its issuance or execution, surveillance conducted under a FISA order may not lead to any further proceedings in court. And given that the FISA application process is conducted ex parte, and often only the government's position is represented, although we are now using, at Congress's authorization, more appointed amicus curiae or friends of the court who are pre-cleared so that they can get access to the classified information. How can it be said that the process involves a case or controversy? This question only intensified after FISA was amended by the USA Patriot Act in 2002 to include authority not just over applications for individualized surveillance orders, but issuance of orders under Section 702, which approved the government's proposed procedures for the targeting within the United States of persons reasonably believed to be outside the United States without individualized judicial findings of probable cause as to each target. To put it another way, Section 702 governs the collection within the United States of communications of non-U.S. persons who may be located outside of the United States when those communications transit portions of the internet backbone in the United States or are handled by U.S. service providers. Section 702 could be a topic of an entirely separate lecture, but for now I simply wish to note that FISA court proceedings, especially when it comes to the approval of Section 702 procedures, are unlike any other proceeding in the federal court system. They therefore can be seen as a form of judicial compromise, albeit a greatly beneficial compromise, because they now allow judicial oversight of what had previously been entirely an unsupervised executive function. The last set of developments that I want to discuss tonight brings us to the end of the 20th century and the immediate aftermath of the terrorist attacks of September 11, 2001. As you've heard, FISA grew out of a distinction between surveillance for law enforcement purposes and surveillance for foreign intelligence gathering. That distinction continued to generate vexing legal questions after FISA's 1978 passage, which had to be squarely addressed after 9/11. FISA, as originally drafted, required the executive branch to certify in its application that, quote, the purpose of the surveillance is to obtain foreign intelligence information, end quote. But as part of the USA Patriot Act, that language was changed so that the executive must certify, quote, that a significant purpose of the surveillance is to obtain foreign intelligence information, end quote. Why was this change made? In part, the change arose out of the fact that the Supreme Court had not, and to this day still has not, decided whether there's a national security exception to the Fourth Amendment's warrant requirement. Although FISA provided statutory procedures understood to comport with the Fourth Amendment, because FISA applications are based on foreign intelligence, federal courts after the Keith case and around the time of FISA's passage still wrestled with how to undertake a Fourth Amendment analysis in cases involving both foreign intelligence gathering and gathering for domestic law enforcement purposes. And this is best illustrated by the Fourth Circuit's Truong case decided in 1980. David Truong and Ronald Humphrey were convicted of espionage, conspiracy to commit espionage, and several other offenses for transmitting classified U.S. government information to representatives of the Socialist Republic of Vietnam in preparation for the Paris peace talks. The warrantless searches and surveillance that led to their convictions were conducted before the passage of FISA. So the First Circuit was essentially faced with the question that the Supreme Court had left open in the Keith case. Namely, is there a national security exception to the warrant requirement when it comes to foreign intelligence? Surprise, the Fourth Circuit said yes. The court reasoned that because of the need of the executive branch for flexibility, its practical experience, and its constitutional competence, the court should not require the executive to secure a warrant each time it conducts foreign intelligence surveillance. Importantly, however, the court held that the executive should be excused from securing a warrant only when the surveillance is conducted primarily for foreign intelligence reasons. Because once surveillance becomes primarily a criminal investigation, the courts are entirely competent to make the usual probable cause determination, and because, importantly, individual privacy interests come to the fore and government foreign policy concerns recede when the government is primarily attempting to form the basis of a criminal prosecution. FISA, as originally drafted, appears to satisfy the Fourth Circuit's primary purpose test and was interpreted in that manner. But the Justice Department had growing concerns, as demonstrated during the Aldrich Ames espionage prosecution in 1994, that due to the numerous prior consultations between FBI agents and prosecutors, the judge might rule that the FISA warrants obtained in that case had been misused. That is, that the line between surveillance for foreign intelligence information and surveillance for domestic law enforcement had been crossed. In 1995, Attorney General Janet Reno, with the assistance of Deputy Attorney General Jamie Gorolich, issued formal procedures aimed at managing information sharing between the FBI on the intelligence side and Justice Department prosecutors on the criminal side. Over time, these procedures came to be referred to as the wall, and they eventually came under criticism after 9/11 for blocking the arteries of information sharing that might have prevented the attacks. In the immediate aftermath of 9/11, the wall came down. with Attorney General John Ashcroft directing as much information sharing as possible and Congress changing the purpose language of the FISA statute. FISA now provides that obtaining foreign intelligence information need only be a significant purpose of the surveillance. But would the Fourth Amendment still be satisfied if the primary purpose of the surveillance conducted under a FISA order was for law enforcement, and gathering foreign intelligence information was only a secondary purpose? The question came before the Foreign Intelligence Surveillance Court and then the Foreign Intelligence Surveillance Court of Review in 2002 in Re Sealed case. Now, heretofore, the courts have not published very many of the decisions publicly because they involve so much classified information. But Congress, when it tried in its more recent tinkering with the FISA statute, tried to make the process more transparent, has directed the Attorney General to basically take our opinions and, if necessary, redact them, but to produce as much of the opinion as possible. So if you pull the federal reporters, you'll see these opinions where you turn the page and it's either totally blank or there's like a big black square. That means that the information was redacted by the executive branch because they think it might reveal methods or means by which the information is gathered. It's usually not so much that the information itself is so sensitive, although it can be, but that by knowing that we know the information, the bad guys will figure out how we got it. And so that's why they redact all this stuff. But in Re Sealed case, and we try to write these opinions as heavily directed towards the law and less reliance on discussing the facts, which of course normally as a circuit court judge you try to weave the facts with the law so everybody understands your grand reasoning that led to the conclusion. And that's hard to do with writing opinions in the national security arena. So you say as little as possible about the facts and as much as possible about the law. So hopefully our opinions will become more readable in the future. I leave it up to you to decide that. Going back to in Re Sealed case, the government appealed from an order of the FISC imposing certain requirements and limitations regarding FISA surveillance. Specifically, the FISC had ordered that law enforcement officials shall not make recommendations to intelligence officials concerning the initiation, operation, continuation, or expansion of FISA searches or surveillances, and that the FBI and the DOJ shall ensure that law enforcement officials do not direct or control the use of the FISA procedures to enhance criminal prosecution, and that advice intended to preserve the option of a criminal prosecution does not inadvertently result in the criminal divisions directing or controlling the investigation using FISA searches and surveillance toward law enforcement objectives. On appeal, however, the FISCer pointed out that the wall emerges from the FISC's implicit interpretation of FISA, the same wall that the language change in the USA Patriot Act was intended to tear down. So in Re Sealed case goes on to thoroughly rebut any notion that FISA, as written in 1978, included a primary purpose test, and points out that Truong was not a FISA decision and dealt only with the Fourth Amendment and the boundaries of the president's inherent executive authority. And the FISCer noted that by asserting authority to govern the internal organization and investigative procedures of the Justice Department, which are the province of the executive branch under Article 2, and the Congress under Article 1, the FISA court may well have exceeded constitutional bounds that restrict an Article 3 court. In other words, the FISC apparently felt that the FISC was not sticking to the grand bargain and that the delicate balance was becoming unsteady. Ultimately, in Re Sealed case concluded that the Patriot Act eliminated any statutory justification for the FISA court to balance the relative weight the government places on criminal prosecution as compared to other counterintelligence purposes. And without concluding that a FISA order is a warrant contemplated by the Fourth Amendment, the FISCer held that FISA, as amended is constitutional because the surveillance it authorizes are reasonable. After In Re sealed case, the wall, at least with respect to the FISA courts, had well and truly crumbled. In order to satisfy the requirements of FISA and the Fourth Amendment, the government is not required to show that its primary purpose for engaging in surveillance is to gather foreign intelligence information. The balance was shifted through legislation and subsequent judicial interpretation, and there it currently remains. There is much more to say about the evolution of FISA since 2002, including the addition of Section 702, the bulk collection of metadata at one time, but no longer, previously conducted under Section 215 of the USA Patriot Act, and the ongoing changes underway as various provisions of post-9/11 legislation reach their sunsets. However, I fear I would keep you here all night if I tried to discuss all of these with you. Instead, I hope that you take away a few key concepts from today's national security history lesson. First, that FISA and the FISA courts were created to provide an important check on executive power. That role is just as important today as it was in 1978, perhaps even more so in light of current events. Second, that each of the three branches of government work together to reach the grand bargain that FISA represents, and that they continue to give and take as technology continues to evolve, and as the United States continues to face threats both internal and external. I sincerely hope you trust that the judiciary takes its constitutional and statutory oversight responsibilities very seriously. The executive appreciates that its agency's determined effort to protect the country from espionage and terrorist attack must comport with the fundamental principles embodied in our Constitution as judges interpret the law to guide their work. And the Congress continues to refine the statutory scheme in order to achieve the best possible balance between individual privacy and national security. Every branch, through FISA's complex history, has earnestly attempted and continues to attempt to hold that delicate balance steady and true. Thank you very much. Are we going to a reception, or do you want to take time for questions? I've kept you here about an hour, so I don't want to overstay my welcome.
Sure, if anyone has any questions, feel free to.
I may not be able to answer them, but yeah.
So, first of all, thank you so much for the talk. That was super informative, and I'm happy that you contextualized it so much because it made it really very interesting and be very easy to follow. I'm curious. I know in the mid 2010s there was a debate about whether a special advocate should be appointed, and I'm wondering if you could maybe discuss either from your own personal opinion or the opinion of the judiciary more broadly, what some considerations either for or against that were. I know the appointment of amicus curiae was kind of not like a consolation, but kind of a way to at least meet some of the requests that were going on with that, or like to address some of that debate. So I'm curious if you could go into that.
Okay, if I can reformulate your question so that everybody understands what the question is. There is no particular role for special advocates to represent the target of the surveillance, because this is very much in the investigative stage. But Congress decided, and there was a lot of debate over it, to authorize and very much encourage the FISA courts to appoint amicus curiae in order to give a countervailing view to the government's one-sided presentation in support of their applications. You do have proceedings involving third parties who are resisting compliance with the FISA court orders to turn over tangible things. They are very well represented by counsel, and it's a much more traditional adversary proceeding. And so Congress settled on a procedure I touched on briefly to appoint 9 lawyers with significant experience in the national security arena. And I don't have the list in front of me, but it includes people who were formerly in the National Security Division, people from interest groups like the Electronic Frontier Foundation, or lawyers who represent sort of privacy, litigation, people involved in that sort of thing. And all of these, there's Professor Laura Donahue from Georgetown University's National Security Law Center is one of our amici. And all of these folks have, as I mentioned, been their security clearances have been already obtained. So we are required in any case that may present a substantial or novel issue of law to appoint one of these lawyers as amicus curiae. And we're doing so more frequently now than we did in the past. And they are incredibly helpful to the court in terms of giving us sort of a more balanced view. And I hope our decisions will be better informed. So I'm a fan of it. But bear in mind, they are not there like a defense lawyer who would be representing the interests of someone who is under investigation. They're there to make sure that the government doesn't run roughshod over liberties and privacy rights of the public generally, and I think they perform a really valuable service in that regard. Good question. Anybody else? Yes?
I am curious as to what remedies are available if executives fail to comply with the procedural requirements.
That's a great question. The question is what remedies are available if the government doesn't abide by the restrictions. We have, as any Article III judge has, contempt authority, which we could invoke. I guess that's the quick answer. We have on occasion referred matters to the inspectors general of the relevant agency in order, or task the lawyers representing the government to, in essence, conduct an investigation and report back to the court on their compliance with minimization procedures and that sort of thing. And then, of course, you now have these congressional oversight committees that are becoming very active and summoning executive branch officials to testify before the various committees of Congress. Statutes have been amended in order to try and address some of the abuses. The one I mentioned that would take a while to explain is the Section 215 authority that the National Security Agency had been involved in. Congress put an end to sort of the collection of bulk metadata that it was getting from various sources. So in that respect, I think the oversight activities have stepped up substantially. And I think that's a good thing, too. What is the old saying? Power corrupts, and absolute power corrupts absolutely. So we're trying to prevent that. Anybody else? Well, thank you all. It's been a real pleasure to appear before you and come back to Montana.